Hello and welcome to the Nuts and Bolts of Elder Law. My name is Kenneth Vercammen, and I'm here to discuss with attorneys and professionals how to help set up their practice and handle wills and estate planning. The phone call comes into the office. That's a good ring because it often means a new potential client. Sometimes the first question that's asked is how much? Well, that always depends. The size of the estate, the amount of work. If someone's looking for a $100 will, we advise, well, that's not something we do. We try to do the best work possible. And we also know that the attorneys who don't do the $100 wills aren't doing self-proving wills. They're actually doing the wills wrong. Many times people call and they want to talk to the attorney. They have questions. Well, that's what we do. We solve problems, we answer questions. That's what we do for a living, and that's how we pay our staff. So we ask the people to come in. Free consult. Well, if someone wants free, they can go to the library and read books. Typically most attorneys, my office, we charge a $200 consultation fee. That way we're able to find the people who really need quality legal services and someone who's not looking to spend money on an attorney. So if someone's a professional, you want a client, well, try to get them in. People need encouragement. Sometimes someone says, I'm busy. Well, busy doing what? This is important to you. This is important to your family. So it's a good idea to email an appointment letter. You get the email address, you email out the information when the appointment is. So I told them, write this down, email appointment letter. Because we also want to say, will the person follow instructions? And in the office, once they have the office consult, there is the will questionnaire or an estate planning questionnaire. And we've even put our will questionnaire on our website, njlaws.com. So the person comes in. Did they fill out the form? Does it have all the information we need? We don't make seniors wait because seniors are on military time. If their appointment is at 3 o'clock, that's when I want to see them, as long as their confidential will questionnaire is filled out. Now, the will questionnaire is not that complicated. Ask them their name, if they're married, where they live, some other basic information. The next page, executors. Who they want, and we ask the client regarding the executor, are they able to do the job? Sometimes someone will ask me, why do I even need a new will? I'm married. Well, obviously married people with assets, two people aren't going to live forever. We don't recommend joint executors. There's a reason why there's not two presidents of the United States. Assets. Our questionnaire asks questions about assets, not specific things. Basically, let's see, what are your major assets? Where is your real estate? Let's see, any big life insurance policies. Are the assets more or less than $1 million, more or less than $2 million, more or less than $3 million? It's important for the attorney to explain that items where there's a joint beneficiary or payable upon death, those don't pass under the will, but those pass by law, or by contract. Life insurance, even though it goes automatically to the survivor, it's important that the amounts of the life insurance are known, because sometimes there's estate tax implications in those. And the final, most important question we discuss with the clients is, who gets your stuff? Who do you want to get your stuff? Who's number one? Who's number two? Sometimes people have specific bequests. Well, that's fine, but that should be, something written on the form, and later on we'll put within the will. Someone may say, well, Mr. Spigner, I'm married, all my assets are joint, why do I need a will? Well, it's easy to explain. No one's going to live forever, and the second person is not going to live forever. And it's better to have all the estate planning done right away. It's important also to know the ages of the children. If there's minor children, we don't want minors to get money outright. If children are disabled or if you don't want someone to get money outright because someone's a spendthrift, someone's in bankruptcy, someone is going through a bad divorce. If there's minor children, you need to ask the question, well, who do you want to be the guardian for the children? Let's see. And also we ask at the conclusion of the appointment, okay, what questions do you have? Let's see, what questions do you have? Let's see, and that's one of the 4 questions on our questionnaire. Let's say again, if they have to wait a few minutes, let them write their questions. And lastly, how you pay, check or credit card. Most attorneys and professionals now require retainer or fees up front. We ask the question, who filled out the form? And we get into ethics now and conflicts of interest. And see, who is the client? And a portion of, so that's important as for the will questionnaire. And there's more information on our next section dealing with preparation of the documents and signing the documents. Thank you.